LawPod. My name is Wray and I am a final year Law with Politics student here at Queen's. My specific interest on the podcast is opening up access to law and spreading awareness to students about the variety of paths available with a law degree. Alongside me is my fellow student Sarah McMahon. Sarah, would you like to introduce yourself?
Thanks, Karen. So yes, as you've mentioned, I'm a second year Law with Politics student here at Queen's as well. I have a similar interest in overcoming barriers to the law, and I hope that I can use this platform to bring some awareness to those who may face some obstacles in accessing the law disproportionately.
Today we welcome Dr John Taggart, a criminal law lecturer who has recently joined the law school staff. Hi John, would you like to introduce yourself and tell us a little bit about your career and research interests?
My name's John Taggart. I joined the School of Law at Queen's in December 2022, so I've been here just over a year now. My research interests are criminal law, criminal procedure, socio-legal approaches to law, and I teach criminal law and sentencing at the School of Law.
Could you tell us a little more about your path to becoming a legal academic? I know that you practiced before, so what made you choose the academic path as opposed to staying practicing?
Yeah, so I graduated from Queen's and went straight to the Bar of Northern Ireland. I started practice after my pupillage. I practiced pretty much exclusively criminal defence work. I then moved to a criminal defence chambers in London, where I practiced mostly criminal defence work and quite a bit of regulatory work, basically prosecuting healthcare professionals, which is an interesting follow-on from criminal law. It was during my time in practice in England and Wales, actually, that I started to see a new role called the intermediary. And I had heard about the intermediary in books and in some of my legal research, but never in practice. I developed an interest in how this role operates. I thought there wasn't a lot on it in the literature, and I applied to do a PhD at the London School of Economics and got accepted. Whilst I was doing my PhD, I was still practicing, and I was also teaching law at the time. Now, those are three difficult plates to spin at the same time. So something had to give, and criminal law is very court heavy. You really have to be in court a lot for trials and court appearances. And it got to the point where I had to pick, did I want to be a barrister with a PhD and continue to practice, or did I want to pursue the research interests with the PhD? And I chose to do the latter.
So you outlined that your research is on intermediaries in the criminal justice system. Could you begin by telling us what intermediaries are?
That's a good question, because my thesis is entitled The Role of the Intermediary, or Exploring the Role. And truth be told, a lot of people don't really know what an intermediary is, even a lot of lawyers and other legal professionals. So there is still a lot of ambiguity about what the role is and what it involves. But in simple terms, an intermediary is an independent, impartial communication expert who assists the courts, police, and other criminal justice professionals to communicate with a vulnerable person. That will be a witness. It can be a suspect or defendant who has some sort of vulnerability, and they need some assistance to communicate, mostly in court with lawyers, with the judge, but also with the police at the investigative stage of the criminal process. An intermediary will be requested to attend a vulnerable person. They will conduct a communication assessment. They will then write up a report with practical examples and practical strategies to help lawyers, judges, police to communicate with that vulnerable person. Intermediaries mostly come from a speech and language therapy background. There are other professions as well, but it's mostly a speech and language therapy role. And as I said, their main aim is to facilitate communication. And it's really important to stress they don't work for the defence. They don't work for the prosecution. They are an officer of the court.
So then, am I right in thinking that intermediaries are involved in every stage of the criminal process?
It's a really, really good question. Because when the role was first conceived in the legislation in 1999, the Youth Justice and Criminal Evidence Act, it wasn't really clear at all when this role would be involved. It basically envisaged that the intermediary would facilitate communication and wasn't specific about where that would be. So in the initial cases where witnesses were assisted by intermediaries at court, that meant that the intermediary would basically sit beside the witness in the witness stand. They would be with them while they're being questioned. And after that, the role of the intermediary really stopped because there was no other involvement in a case for a witness and they wouldn't have to communicate with judges or lawyers beyond that. The difficulty around appointment of intermediaries and duration of their involvement is more pronounced when we're dealing with defendants. And that's because the role and involvement of a defendant in the criminal process is invariably broader than for a witness. So, for example, when a suspect's being questioned at the police station, they're interacting with police. When they're instructing their lawyers before court, that's communication. When they're in the dock, for example, when they're watching the rest of the evidence, when they're in court with the judge being cross-examined, all of that is communication. So to answer your question directly, originally intermediaries were envisaged to be a relatively narrow role, but as time's gone on and as there's been development of practice, we're now starting to realise that in fact this role has a much bigger part to play than probably people realised from the outset.
Despite the initial ambiguity, then, it really is a vital role.
I would say it's a vital role. I definitely fly the flag for the intermediary. I think increasingly lawyers, judges, and other criminal justice professionals are coming round to seeing the value of intermediaries. Although I wasn't in practice when the role was first rolled out in England and Wales, you do hear a lot of stories from the initial intermediaries who worked in court about the real lack of understanding of what the role was, what it did, who they worked for. Lots of genuine questions about a new role in the criminal process. But your question was, is it a vital role? It's a very important role, and I'll put it simply this way. There are people who are able to give evidence now in criminal proceedings, whether that be children, whether that be people with other vulnerabilities. There are people who can give evidence now today who otherwise would not have been able to do so because they need specialist communication assistance. Now, if you're looking at the criminal justice system, it's in everyone's interest that the best quality of evidence can be produced, and intermediaries help facilitate that. So I would say strongly, yes, it's a very, very important.
So was it this importance, or what else that's initially sparked your interest in this area of research?
I think what initially sparked my interest in it was that it was so new. I knew from my studies at Queen's actually about a range of special measures that had been introduced in 1999 to help people give evidence in court, whether that means they were intimidated or they were stressed or lots of different reasons. There were special measures introduced and the intermediary was one of them. But up until that point, there hadn't really been much written about it or not much was known about it. I found myself in the position where I was in practice. I was started to see this role. It was real life. And I thought, we really need to know more about it. Judges need to know more about it. Lawyers, as I was then practicing, need to better understand the interactions that this role has with judges, lawyers, and others. And there was a gap. There was a gap there for someone to come along and do it and to do the empirical research, to gather the data, to do the interviews. And I realized early on that there was a real appetite among intermediaries to have their side of the story heard because they felt that they weren't being respected or viewed as a legitimate criminal justice professional. I realized that after starting my research, to be fair, but people were very happy to speak to me about their experiences. And I think when people are happy to do that and want their side of the story heard, they probably haven't been listened to. And that's definitely what I found.
So, John, are there particular groups of people that intermediaries tend to support the most?
I think that's a really good question because the reality is that vulnerability exists everywhere. And we spoke briefly about suspects, defendants, and witnesses being assisted by intermediaries. And the reality is that there is vulnerability in all groups of people who come before the court to give evidence. In terms of vulnerability types or categories, it's actually interesting because in Northern Ireland, the Department of Justice, in reviewing the first year or so of the intermediary scheme here, published quite a lot of data on the types of groups that were being assisted. So, for example, it's not surprising that children are assisted the most by intermediaries because by virtue of being a minor, you are entitled to the assistance of an intermediary. You don't need to demonstrate anything other than being under 18. But when you look at adults, that's probably a bit more telling and a bit more interesting because really the range of vulnerabilities are quite stark, actually. So, for example, learning disability is quite a high percentage of individuals who are assisted by intermediaries. We have people who suffer schizophrenia, cerebral palsy, people who are deaf, mute, or selective mutism. People with mental health issues make up a relatively big proportion of those assisted as well. Autistic spectrum disorder and also things like dyspraxia. So there's a real range, and it just shows how vulnerability really doesn't come in one neat package. So intermediaries really have to have a wide skill set, and it does come back to what I said earlier about speech and language therapy, because you will have some intermediaries who work mostly with children because of their background, working with children as speech and language therapists, and then others will specialise in other areas. So some intermediaries, particularly in England and Wales, will focus on older witnesses or older defendants based on their previous occupational experience.
Given that I'm personally very interested in identifying groups that their access is disproportionately affected to the law, I think it's great to see a prime example of how the law is evolving to represent that. Do you think that it is reasonable to ascertain from the information you just gave me that certain groups are disproportionately in need of intermediaries?
I think a really important point to note there about the need for intermediaries is this. There is a big need for intermediaries, but intermediaries are only useful if the need for them is identified. It's a huge issue in lots of countries, not just in the UK, but also in several European countries where the need for communication assistance is now becoming more prevalent, but also in Australia and New Zealand where research of this kind is taking place as well. I'll give you an example. In police custody, you are far more likely to find people with vulnerabilities such as mental health issues than the general population. The figures on that are crazy. But are police sufficiently trained to identify vulnerability? The answer is no, they're not. The question about detection of vulnerability then shifts to, well, whose responsibility is it to do that? So, interestingly, in England and Wales, there's no duty on police to actually identify vulnerabilities among suspects. It's good practice. There is guidance on it, but there's no duty. In Northern Ireland, we actually have a better system, I would suggest, than in England and Wales, because we now have an embedded nurse practitioner team. They're called forensic nurse practitioners who are embedded into the custody suite, and they can actually give practical guidance to custody sergeants, not to identify vulnerability per se, but if a custody sergeant has questions about whether someone is vulnerable and whether they can communicate and follow basically questions in police interview, the nurses can actually assist and provide guidance. It is merely guidance. Doesn't bind the police, but they can assess them based on their medical record as well and provide guidance to the custody sergeants in the custody suite, whether or not that person's fit to interview, whether they're fit to detain. So all of that to say, which groups are disproportionately represented? The figures are probably a bit skewed because we don't have good enough vulnerability detection procedures. But if you want an interesting case, or if the listeners want an interesting case to look at further, is the condition of suspects in police custody. They are far more likely to be vulnerable and far more likely to suffer things like mental health disorders.
Brilliant. By the way, for anybody listening who's particularly interested in how vulnerable groups in society are treated by the policing arm of the criminal justice system, there is a recent episode on the LawPod dealing with policing in Northern Ireland that you might want to check out. So, John, given that the law is constantly evolving as the role of intermediaries exemplifies, where do we go from here?
That's a really big question, but it's a very important question. Because I think what intermediaries represent is an awareness and a recognition that the adversarial criminal process that we have, and have had for a long, long time, is not fit for purpose. So intermediaries being one of the special measures introduced to accommodate vulnerable individuals at least recognises that individuals with communication difficulties do need assistance. if they're going to be able to give their best evidence. So before answering your question, I do think it's important firstly to acknowledge that the intermediary does represent change. For example, Louise Ellison, who's written a book about the principle of orality in adversarial proceedings, talks about how wedded lawyers, judges are to the adversarial process. Lawyers train to ask questions in an adversarial way. Judges are recruited from the bar mostly. So this is really embedded. So we have had some change to date. To answer your question directly, where do we go from here? Probably the most optimistic, maybe slightly unreasonable or unlikely way to fix the system is an overhaul of the adversarial model. Now, if I'm being honest, that's not going to happen today or tomorrow. Realistically, what I think we can do is use the experience of intermediaries and the other special measures that have been introduced to act as agents of change. The fact that we can now have a cross-examination of a vulnerable witness, possibly a very young child who may be 4 or 5 years of age, the fact that we can have that young person give their evidence in court with the assistance of an intermediary would not have happened 40 years ago. It wouldn't have happened 25 years ago. So that is really good progress. Where do we go from here? It's about culture change. Now, the intermediary is only part of that. It's only a small part of it, but we need to ensure that the people working in the system, whether that's police, whether that's lawyers, whether that's judges, appreciate that the old models of adversarialism, where the lawyer could ask whatever they wanted, are gone. We have to better respect the needs and rights of those who come into contact with the criminal process, because the changes that we've made are a start, but we need to not get complacent, and we need to be sure that the most vulnerable people in society are able to come into contact with the criminal process and feel that they can have their side of the story heard.
Well, it's certainly very reassuring to hear and be reminded of the progressive nature of the law. Speaking of the progressive nature and perhaps the tendency within the law to be resistant toward that, I would like to speak on the topic of legal terminology or legal jargon. You said in an article on the Frontiers of Social Legal Studies, there is a public conception of lawyers that they're considered to speak verbosely or with marbles in their mouths, as you said. From your experience and practice, combined with your research speciality in this area, do you believe that legal jargon is perhaps a part of law that needs the most evolution in order to invoke this change that the intermediaries are attempting to begin?
Yeah, I think, again, first and foremost, it is important to recognise the changes that have happened over the last 20, 25, 30 years. Again, the intermediary is proof that change can happen. And I think the way vulnerable people are questioned in court today is different to how it was done before. Speaking to some lawyers from Ireland recently at a conference, they just were talking about how the fact that berating or badgering a witness that used to happen does not happen anymore and is not allowed to happen anymore. So that's good to hear. That's progress. I think in terms of changing cultures, linking back to my previous answer, but also in relation to the way lawyers speak and the way lawyers interact, that starts with training. That starts with how lawyers are trained and the models in which they're trained in. We're not going to click our fingers and overnight get all members of the bar, for example, to adopt a plain English approach. But there is a drive from the judiciary for that. Obviously, intermediaries are there to ensure plain language speaking. But in fact, if you actually zoom out and take intermediaries out of the question for a second and take the most vulnerable people out of the question for a second, lawyers and judges should be dealing with clients in plain English anyway. If we don't, then the law does not become accessible. I remember when I was doing my pupillage and I had a university degree and I had just been through my year's training, stepping into court for the first time and seeing the word antecedents. I hadn't a clue what it meant, and I was a pupil barrister. And then you hear things like arraignment, and you hear lots of other terminology, which people who are considered, typical find difficult to understand. So I think a root and branch change of how the law is communicated is really, really important. I would hope that the changes that have happened over the last 25 to 30 years, and again, I come back to it, the intermediary is proof of that, is a harbinger for future change that can happen. And ensuring that in 20, 30 years, when we're looking back at 2023 and where we are today, we can recognise there have been even more developments. And where intermediaries fit into that, that's an open question. But we need to constantly improve accessibility. And that's what it's all about, really. If the criminal process isn't accessible, then I think we're failing as a criminal system.
Great. Thank you, John. It's absolutely great to hear that the role of intermediaries and their wider purpose of creating a more systemically accessible law is great to hear, especially given that we know that there are groups of people who are disproportionately affected by it. Thank you, as I say, for the answers and as well for your time, as we have now arrived at the end of the interview. Your insight on the criminal justice system and the groups of vulnerable people that it affects was illuminating. Thank you, the listener, for listening in on our discussion today with Dr. Taggart. We hope that you've enjoyed this episode of LawPod and that you tune in again soon. Bye for now.